Hello and welcome everyone to our presentation today entitled Seniors 301, the Fragile Framework of Senior Protection Exposure Under Existing Law. I know from looking at the attendees for today, a lot of you have been participants in previous webinars on this topic, which was more of a 101. This is kind of the advanced course that is based on the 101. And we'll get into the substance of what we're going to be talking about today in just a minute. First, I'd like to introduce myself and the panel. I am Angela Turiano, a principal in the New York office of Bressler, Amory & Ross. With me today, also from the New York office, is Joseph Calabrese, who is also a principal. And Joe and I have known each other for a very long time. In fact, we were prosecutors together in the Brooklyn DA's office, a fact we always have to bring up when we do this webinar. And that is the representation from New York. The rest of the panelists hail from the great state of Florida. First, we have Alex Sabo, and then we have Sarah Soto, both principals from the Miami office. And joining us from Fort Lauderdale, we have Associate Taylor Bandy. We are all, as a group, members of the firm's Financial Institutions Practice Group, where we represent financial advisors, broker-dealers, and investment advisors, again, sales practice complaints, regulatory inquiries, and some employment matters. But more importantly, for today's presentation, we are all members of the firm's Senior and Vulnerable Investor Group. And this was a group that was formed, I think, about 6 years ago at this point to address the growing concerns of senior exploitation, which we'll be discussing today in some detail. And we, in this regard, we represent both them generally, as well as we advise clients how to best address these issues of protecting both their senior and vulnerable clients, as well as protecting them against any litigation emanating from this type of fraud. The group also does training for our clients, such as this webinar we're about to do for you today. In addition, we will work with our clients to review and sometimes revise their policies and procedures to best comport with the legal framework that exists to protect seniors. And in addition to that, we everyone in this group has actually represented our clients with regard to litigation that has stemmed from financial exploitation. As I mentioned, this is an advanced course, and today we are going to be discussing a variety of topics. And by way of background, in our 101 course, we basically went over stats that spoke about the aging population, specifically the baby boomers that are all now aging, and the increased financial exploitation that we're seeing with regard to these seniors. And the increased financial exploitation has to do with a lot of factors, but the increase in technology, specifically the internet, as well as the increased ability to detect the fraud. So we talked about that in 101. We also spoke about the rules in place, the legal framework. You have federal rules, you have state rules, which vary state by state. And for those of you who have seen this presentation before, you know Bressler offers a map. If you just put into Google Bressler map, it comes up a map of the United States. You click on your state, it tells you exactly what you need to do to report suspected financial exploitation in any state that you choose. In addition to that, we also spoke about various FINRA rules, for example, 4512, which is the trusted contact person rule, where a customer is urged to pick a trusted person that can serve as a resource for a financial institution to speak to should they suspect financial exploitation. We also spoke about rules involving disbursements, and hold on disbursements, and even a hold on transaction with the suspicion of financial exploitation. And I give you that background because we have now, since FINRA and the SEC really took hold of this senior exploitation and the rise in it back in 2013, and we've watched how the rules have developed to increase protection for senior investors and also to provide firms a legal safe harbor should they suspect financial exploitation, a way to tell them, okay, if you follow the procedures in these rules, and you escalate this suspected fraud, you are protected from any potential exposure or liability that can result from your actions. So we have this legal framework in place. So where are we? And that is what we're going to discuss today. Because we have this legal framework in place, are seniors protected? Are they better protected? And are firms fully protected from exposure if they follow the rules? And as you can see from the slide in front of you, today's discussion is going to focus on, first, investor protection versus privacy concerns and investor autonomy. And this topic sort of emanates throughout all the topics. You see this balance of trying to protect the investors, but at the same time respecting their rights, their privacy rights, and their rights to basically do what they want. We're going to talk about protecting seniors versus complying with state POA statutes. Then we're going to discuss what happens when the hold period provided by statute ends, and recent litigation trends. We'll advise you of best practices in when the hold period ends. We're going to talk about the trusted contact person under Rule 4512. What happens if that person turns out to be the fraudster? And finally, you did what you were supposed to do. You reported it. Law enforcement and APS didn't take action. What do you do? Where does that leave the firm? So that's an overview of what we're going to be talking about today. I'm going to turn it over in just a second to Alex Sabo. I will tell everyone, as is usual with these presentations, halfway through, I will be providing you guys with a code. The first half and the second half, after it's over, I'll give you the second half of the code, and you'll need to present that phrase in order to get your CLE credit. And with that, I'm going to turn it. Oh, and also, if we have time at the end, Alex Sabo, who is a part-time amateur chef, is going to share a recipe with the crowd. So hopefully we have a few minutes left for him to share that with everybody. And with that, I'll turn it over to the amateur chef himself, Mr. Sabo, to talk about investor protection versus privacy concerns and investor autonomy. Alex?
Thank you, Angela. Thank you for that wonderful introduction. And talk about investor protection. We put up FINRA Rule 2165, the definition of financial exploitation. But that's not the only definition that applies. You can find plenty of definitions of exploitation. For example, in Florida, we have an Adult Protective Services Act, and that has a definition not only of exploitation of persons, but also financial exploitation. Florida has a protection of specified adults in its Blue Sky Law, and that's got a definition of financial exploitation. But we decided to put up the FINRA Rule 2165 definition. And what are we trying to do? We're trying to make sure that we can protect persons that are covered by the statutes or by the rules from having their assets taken away from them. And that's really, remember, at the bottom line, that's what it's all about. That's what we're trying to protect, because when the money's gone, the money's gone. So that's the goal. All right, so let's move on and talk about privacy concerns. Privacy concerns are everywhere too. They're in state constitutions, the United States Constitution. They are in federal law. They're in rules and regulations, state statutes. So it's big business, and you have to be concerned about privacy of individuals. And I'm involved in a case now for one of our clients, and our client filed an interpleader. And one of the lawyers in the case just got into a lot of trouble because in making a filing, the lawyer included the Social Security number of an elderly person involved in the case. And not only did the lawyer get fined by the court, not only did the lawyer have to pay the attorney's fees and costs that the other side incurred, the lawyer had to go back and take an ethics course at his expense and prove to the court that he'd done it. So privacy is a deep, deep concern. However, there are exceptions. For example, FINRA Rule 2165 and 4512, you can talk to a trusted contact person. Taylor's going to spend some time on trusted contact persons. And you can report financial exploitation. In Florida, and I use Florida as an example because I'm in Florida, you report to the Office of Financial Regulation if you place a hold on a transaction or a distribution from an account. And you only provide limited information because that information is publicly available. So you only talk about the gender, age, and zip code of the residence address. Now, generally, that's going to be followed up by OFR. They'll ask for more information. But the key here, and we'll talk about this a little bit more in the program, information that relates to investigations undertaken by the Office of Financial Regulation is confidential. That's not going to be subject to public disclosure. So you can disclose confidential information to the Office of Financial Regulation. Adult Protective Services has got a central abuse hotline you can call. That also is confidential and exempt under Florida's public records law. So what's the key here? You got to know the law of the state where your case arises about privacy and confidentiality, where the report is made, and you follow it. Same thing holds true if you get involved in court. What can you disclose when you file a case in court? You probably have to redact a lot of information, at least in Florida, under our rules of judicial administration. You have to redact lots of information, addresses, telephone numbers, and social security numbers. And there's a lot more you have to redact. So those are the privacy concerns. It's big business. All right, now, how do we balance that against our other concerns? Well, and how do we protect the investor's autonomy? Now, why is autonomy important? Well, because this was the hurdle we had to overcome in Florida in order to get Section 517.34 of the Florida statutes passed. It was the message we got from the governor's office in 2018. It was the message we got from the Florida Senate in 2019. And at the end of 2019, we were, when I say we, it's the Florida Securities Dealers Association, we're facing an uphill battle. How are we going to get this statute passed? I mean, states around the country are passing the statute. The FINRA rule had been enacted. And what happened was the last committee we had to convince in the Senate, we were told, no, you know what the concerns are. And so what I said was, well, what if we take your concerns, we take it into this strong statement of legislative intent to protect investor autonomy. And that's what did the trick. And that's why we have this particular provision in the Florida statutes. I'm not going to read it to you. You can go and read it, but it's in subsection 2 of the statute, protecting investor autonomy. And that was the concern of Governor Scott. And Governor Scott was 65 years old when we tried to get the statute passed in 2018, and he said, no, I don't want somebody telling me that I can't make a bad investment. So that was the key to protecting investor autonomy and to balance that. Now, what are some practical tips that you should take into account? Well, remember, in real estate, it's location, location, location. And if you want to minimize liability, documentation, documentation, documentation. You're creating contemporaneous evidence of the actions you've taken to address potential financial exploitation. So write it down. Keep detailed notes and detailed records, because that's the first thing that your outside counsel is going to ask. Well, what notes do you have? And did you keep those notes every step of the way? Because that's just great evidence that we can use if something happens down the line. So investor protection versus confidentiality and autonomy. Now, I think I'm finished. I think I'm finished with all my slides. So we're going to turn it over to Sarah, who's going to dive deep into powers of attorney.
Before we get to Sarah, I did want to posit something to the panel, which is that in preparation for today's panel, I was looking around the internet, and I found that in 2018, the SEC put out a white paper, and they recognized just what Alex was talking about, the conflict between investor autonomy and privacy concerns and the protection of senior investors. And thought leaders, that's what the white paper said, thought leaders in this space thought about or posited the idea of putting together a comprehensive way of compiling all the information so that it could be shared among all financial institutions. So right now, privacy laws prevent, let's see, from financial institution A, if they find out, if they have suspicion of financial exploitation against one of their customers, can't share that with financial institution B, where the customer may have another account. So these thought leaders said, what happens if we have a system? We put in together like a kind of like a database. So something gets escalated to the database, and then there's a red flag, and the database is managed by maybe a government agency. And then there's sort of a alert put out to all the different financial institutions the customer's at. And this way the information can be shared and it will protect the investor. And that's just the general idea. Then the paper went on to talk about an even further connection, and that would be with the healthcare system. They actually called it wealth care, which was kind of creative, right? So then the financial institutions can kind of collectively work with the healthcare system. The healthcare system monitors the individual's cognitive abilities, and should they see a decline, somehow that information gets shared. So again, this is just sort of an idea. I just wanted to see what the panel's thoughts were on such a system and issues you think that would arise from having such a system in place.
Okay, I'll start. I'm not adverse to having a system like that set up. It's going to be cumbersome and expensive and require more layers of bureaucracy, both at the firm level and at the government level. I think it might be simpler to either change the FINRA rule or change state statutes so as to provide that a financial institution may share information with a transferring firm regarding the fact that there's been suspected abuse or there's suspected exploitation. I think that might be simpler, but that's just one person's opinion.
Yeah, I would tend to agree with that. I feel like as it stands now, that such a system would require a kind of a huge overhaul of the current laws and rules, and it would also require an overhaul of policies and current existing policies and procedures at financial institutions. So it does seem sort of like a little bit too complex of a way to try to resolve an issue. But I don't know, Alex, any additional thoughts on it?
Well, my concern would be this isn't like a list of people who have been convicted of a crime and they've gotten their due process rights and they've been convicted. You start putting people's names on there just based upon somebody saying, oh, well, this person's trying to rip off my aunt. And maybe there's a family feud going on where they're not trying to rip off the aunt. And once their name's on this list, it's not like it's a do not call list when you don't want somebody calling you, a marketer calling you, you put your own name on there. So somebody else putting your name on there. And I don't think you want to get involved in litigation if it turns out to be wrong.
That's a good point, Alex. I agree. Okay, so with that, let's move on. As we said, the next topic is going to be protecting seniors and complying with state POA statutes, those pesky POA statutes. Sarah, what say you?
All right, so most states have passed some statute that deals with POAs. What happens if you get one? What happens if you accept one? What can you do? What can't you do? This is just a list of some of the states that have passed such statutes. In all of those statutes, the basic idea and the basic policy that's being implemented is that when an institution, a financial institution, receives a POA that complies with the requirements of the statute in terms of its execution, whether there are witnesses, whether it needs to be notarized, et cetera, the financial institution essentially is immune from suit for following the instructions in the POA. Now, if you've heard me speak at other events or webinars, you know that I'm a little skeptical of these immunities that are granted to firms by statute or by FINRA rule, in the sense that, yes, the immunity is there, but of course, somebody is going to have to decide whether the immunity applied to you, whether it applied under the facts, whether you went too far in one direction or the other. So the fact that the statute basically says that a facially compliant POA can be followed with immunity it's a good thing, but it's not a guarantee that there will be no problems down the road or no expenditures down the road for complying with it. But now, sometimes these statutes are somewhat in conflict. The POA statute wants to encourage the financial institution to accept the POAs, to follow the POAs, to not require a particular form for the POA, etc. And it also wants to encourage the financial institution to protect vulnerable adults or vulnerable individuals, whether seniors or people who are otherwise handicapped and vulnerable, etc. Sometimes these things, of course, come into conflict because here you are supposed to you're supposed to accept the POA and implement it, and by the same token, you're also supposed to, where you suspect exploitation, take the steps necessary to report it and attempt to protect the vulnerable adult. Almost all of these states, and New Jersey being one of the exceptions, but generally speaking, most of these states provide that if you unreasonably reject a POA, or if you reject a POA for a reason not listed in the particular statute, the agent under the POA or the principal under the POA can sue you And if they turn out to be right, that you should not have rejected the POA, the court can award attorney's fees against you for their having to file that lawsuit. Nobody wants attorney's fees awarded against them. So you want to have to try to stay within the statute. The statutes generally give you a time. Some define it as a reasonable time to notify the agent or the principal that you are rejecting the POA. Sometimes that time is extended a little bit if you ask for, extra documentation, such as a certification or an affidavit from the agent regarding various and sundry things. And if you don't ask for those things, then the time is not extended. When the time is a reasonable time, obviously the definition of reasonable is subject to varying interpretations, depending on who is being asked, whether the time was reasonable or not. The other side of that situation is when you get a fixed time. For example, in the state of Florida, you have 4 business days to decide whether you're going to accept or reject a POA. Again, absent you're asking for some extra documentation. 4 days, 4 business days. In the world of a financial institution is 5 seconds from the standpoint of circulating the document to all the right places, having all the right people look at it, having people make the decision, et cetera, et cetera. Now, in connection with exploitation and the issue of exploitation, also most of these statutes will provide an exception to the time limits or to the obligation to accept the power of attorney if the financial institution either has reported to adult protective services or the equivalent thereof in the particular state, or if the financial institution has knowledge that someone else has reported to adult protective services in or the equivalent institution in that state. Now, as Alex and Angela pointed out, in light of the privacy concerns with sharing information between institutions regarding these suspicions of exploitation, et cetera, essentially, unless a family member tells you or the broker somehow found out in connection with the servicing of the account, I really don't know how you're going to find out that anybody else has filed any type of complaint with APS. So I think those instances where that are going to be rare, and that means that you are left in a situation in which you will have to make the report and you will have to comply with it within the times. Now, if we could go to the next slide, please. I'm not going to go through the various timeframes or the various things that you have to comply with. I mean, I think everyone knows that, as I said before, there are 2 legislative policies at issue here. Sometimes they're in conflict. There are the time limits provided under FINRA rules for when you can freeze an account, put a hold on an account because you suspect exploitation, and there are the requirements you have to meet in order to be able to take advantage of that safe harbor. There are the internal policies that you have to have. Those can be very important, and every bit as important is the training in these various statutes and situations. I mean, unfortunately, there is no federal or uniform framework that a firm can refer to when dealing with a power of attorney. It is a state-by-state determination. So you really should have an internal policy, either listing what can be done in every state, which is a lot of work, or providing that you must go to the legal department or to an outside counsel and get an opinion regarding what is required by the law in the particular state for powers of attorney. Training, of course, is very important. You have to be very specific in the case of, for example, people dealing with powers of attorney. There are going to be consequences. As I said, you can be sued and you can have to pay attorney's fees if you wrongfully reject the power of attorney. So you have to be sure that you have complied. There are certain, for example, in the state of Florida, generally speaking, there's a form that you follow when you report abuse or suspicions of abuse to Adult Protective Services. And one of the things that is on the form is that you have to provide the address of the vulnerable adult. Okay, do not be deterred by the fact that you do not have the information to put into that blank. I had a situation in the case in which there was a suspicion that an adult was being exploited by a POA holder. And because that vulnerable adult was known not to be at his former address at that point, he was in a care facility, and the POA refused to provide the information to the firm as to the location of the care facility. So the firm felt, well, can I report this? I don't know where they are, et cetera, et cetera. My experience in that case would lead me to believe that, yes, you must report. Give the last address you have, give an explanation as to why you don't have an address. But people are going to accuse you of not complying with the power of attorney statute, and there's going to be litigation, and there's going to be cost to both sides, and there's going to be the exposure to fees. So if you are going to not accept the power of attorney because you have reported to APS, don't let yourself get deterred from reporting because there's this hoop or that hoop or the other hoop. Act in good faith, make the report, and go forward with what you need to do. Then we have, if we could go to the next slide, what happens when you run out of time? And I think this is an issue that we're going to spend some time talking about here. Joe is going to talk about it, and then probably all of us are going to have some conversation about this. When you report to APS, sometimes when you report to the police, but usually it's APS that's the issue, they do not share a determination regarding abuse with you. So they have certain time limits. If they don't meet their time limits, you may or may not know it. You do not know the result. You do not have the information that you need. So what happens when you put a hold on the account under FINRA rules? You have started the investigation as you were supposed to within a time frame provided in the statute. You've done everything that you were supposed to do, but there's only one problem. The time keeps running, and APS, as far as you know, hasn't done anything. They haven't substantiated the abuse. They haven't said, no, there's no abuse. What do? Because at some point you run out of time, right? And when you run out of time, you run out of the safe harbor. But by the same token, if the time is expiring and you haven't heard one way or the other, and you still believe that there's the possibility of exploitation, are you really going to let the person be exploited and have their money be taken because your time ran out? It's not an easy choice, as my friend Joe Calabrese will tell us all about.
Yes, before we move on, I am going to give everybody the first half of the code today, but just to follow up on a little bit what Sarah said, and that's sort of the essence of this presentation today, which is that, you follow the rules, and yet here you are, and you don't know what's going on, because as Sarah mentioned, APS and the police will not share their information with you. So you can do what you're supposed to do, and then you might still end up, and as we'll share in a little bit, you might still end up being in the same place you were where you started. And on that regard, Sarah mentioned the use of the word reasonable. That word is everywhere in these statutes, but what is reasonable is really up for interpretation. So that opens up the firm to exposure. And finally, even if you do follow the rules, and do everything you're supposed to do, and you go to an arbitration and you get sued and you say, but Mr. and Mrs. Arbitrator, I followed all the rules, I did everything I was supposed to do, and it's not my fault that the senior investor was still exploited. I don't think that's going to go over well with an arbitration panel. So this is the difficult situation we deal with, and this is a big part of our presentation today. So with that, I'll say the first half of the code is happy, 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 for everyone to take down. And now we'll turn it over to Joe Calabrese, who's going to tell us what the firm can do to protect themselves when they follow the rules, but the hold period has ended. So Joe, I'll turn it over to you to impart your wisdom on this topic.
Well, that's a stretch, but I appreciate the introduction. I've also never seen a CLE that had a code word as happy. That's nice. I'm not used to it because there's nothing happy about CLE whatsoever. And nothing that I tell you now is going to make you happy on it.
And Joe, I'm sorry to interrupt you for 1 second. I see there's some questions. I apologize. I see there's some questions that are coming in the Q&A. To the extent these questions are not answered before the end of the presentation, I feel like a few of them will. We will try to get them at by the end of the presentation. We'll save some time, and if we can't, we'll follow up. We'll provide answers post-presentation, but hopefully they'll be answered before the end. So I apologize. Go ahead, Joe.
No problem. In fact, one of them I was just looking at before we started. It's the last one of the queue. This is can you use a hold harmless agreement? And we're going to be talking about actually customer agreements as part of this. So I think it's a timely question. So yeah. So what happens when the whole period ends? We call this, or I call it. This is my shot at creativity for today's webinar. Is a tale of two cities, right? So you have FINRA Rule 2165, which is designed based on public policy to prevent these vulnerable investors, these seniors, and these people who really need us to look out for them from being taken advantage by others. But on the other hand, there are limits to that. So part of it is take care of these folks, but the other part of it is we're not going to give you carte blanche to do whatever you want. Because a lot of my clients have said over the years, listen, all we have to do is freeze the account and then we can't get sued. You know, as Alex said at the very beginning of this, once the money goes out, the money goes out. And there's nothing truer than that, right? Once it disappears into that bank account, you can't trace, you can't get it back. And so that is a very heavy thing that you have to consider. But you've also got to throttle back a little bit and understand what are you dealing with when you decide to freeze that account. Well, number one, especially with what we'll call vulnerable investors, and I'm going to use that term and stop just saying senior, because it's not just seniors, is that the collateral consequences of shutting down someone's account are significant. Most of these folks that we're talking about have accounts that mix their securities and investments with check writing privileges. Most banks will do that. And so while it seems an easy way to put everything into one account, what it really does is it ties your client's ability to pay their caregivers, their nursing homes, their doctors, their prescriptions, their ride to the doctor's office, their therapists, all of these things get tied into their securities account. So while it's easy to say, well, we'll stop investment changes and distributions, you may be cutting off people's ability to pay for their medical care. And that doesn't mean you shouldn't do that. But you have to consider that the consequences here are significant to your client and may result in you getting dragged into court a lot faster than you thought that you would. So I want you to keep those collateral consequences in mind. And I also want you to keep in mind what the policy is. FINRA is all about investor protection. And I think from a policy standpoint, this is the one place that FINRA is going to be on your side if you decide to stop distributions or to freeze, colloquially, an account. The rule almost goes out of its way to keep giving you more time as long as you can show that you're actually doing an active investigation. So the rule at first gives you 15 days, which is in the world of internal investigations and looking at things like this in the broker-dealer world is nothing, right? You can't get 6 emails to all the right people in 15 days. But then they say, but if you still think that there's something going on and you're still doing an investigation, we're going to give you another 10. And that's good too. That 10, candidly, some days is almost as useless as the first 15. But then after that 10, they say, okay, tell you what, we're going to give you a whole month. We've given you now 55 total days to make that investigation and decide what's going on here. Meaning either you're going to hold that money and you may wind up going to court, Alex talked about interpleaders and things of that, or you're going to let the money go. The important thing here is documentation. If you're doing that investigation and you're looking really hard, every phone call you have, every email you send, every internal conversation that you have, every external conversation that you have. Even when people come to you, when the trusted contact comes to you and says, why are you freezing the account? Take notes of those conversations. Because what really happens here is you're protecting yourself, not only from, and we'll talk about outside litigation in a second, from the court system, but you're kind of protecting yourself against a FINRA review. And like I said, it's anecdotal for me. I have not seen FINRA come down hard on people for restricting accounts, because I think at the end of the day, they understand that this is a very important thing we do. And as Alex said before, once the money goes, the money goes. So the question is, though, what can you do? So as the Q&A question was, let me just pull that up again so I can see it. Can you use a hold harmless agreement? I think the answer to that question is no. I think that's way too broad, but we can talk about that. So Angela, if you wouldn't mind popping to the next slide, I would appreciate it. All right. So the good news in litigation is, let's say, this was also my sad attempt at creativity, right? No good deed goes unpunished. What happens when the person you are trying to protect actually sues you? I have handled arbitrations where we restricted someone's account for definitely over the 55 days. And the person whose account was frozen, who appeared to have all of her marbles, except for the days where she was funding the life of her drug dealer grandson with vacations and lavish gifts. So she had her days, right? Wound up coming after us in arbitration and saying, you shut down my account, there was nothing wrong with me, and I had to sell personal property so that I could pay my rent. All of which was true. She came up with all the receipts for all things that she sold in order to pay her rent. Look, we ultimately prevailed at that arbitration, and I know nothing has precedential value in arbitration, but the argument we were able to make that at the time, right, number one, what we did appeared absolutely reasonable. And I do think, maybe somewhat different than others here, that if you can go to a panel and say, I followed the rules and I did something to protect my client, you can look them in the eye and prove that, right, back to documentation. I think that you're in a better position than most, and I think you're okay. But if you wind up in courts, if you wind up doing it to clear yourself because they won't do anything, or they come after you, at the end of the day, if you add vulnerable investor protection to your client agreement, and now I'm talking to those of you who are not our clients at bigger banks, because most of our larger clients obviously all have this. I'm talking to our clients who are smaller in stature, different RAs, and things of that nature, who might be really putting their own shop together. Put this in your client agreement. Explain that in the event that there is any type of dispute about assets, which covers more than just vulnerable investors, that the bank gets to make the decision as to when to make the hold and what factors to be considered. The part that you leave out, and you should leave out, is the hold period, because the minute you write that into your contract is the minute that you're going to be held to it. We have seen, and there aren't a lot of reported cases about this, because most of these cases get settled. I mean, 9 times out of 10, if I wind up with a client in court that says, look, judge, if you sign an order that says I can release this money, I'm going to release this money, that's not going to become a reported case. But the few reported cases that we could find basically say that courts look at this not as a public policy issue like FINRA does, but more of a simple basics, third day of law school contract issue. If you put two people in a room and they agree to something that's open and clear and it isn't as a result of coercion or adhesion or all those fun things that you forgot about the day that you graduated law school, then we're going to uphold those. So the cases that we cite, oddly enough, all involve JP Morgan Chase, and they all ended up in a positive light for the bank. The one that we cited with detail is Brown versus JP Morgan Chase out of Washington State. And this was a very typical meat and potatoes, run-of-the-mill, old lady with a lot of money comes into the bank with a younger person, opens an account, funds the account with all of this money, and then shortly thereafter, the person who brought them there, possibly the trusted contact person, although the case didn't say, seeks to be added as a joint owner, and then seeks to have the original client removed for incapacity. All of a sudden, the bank put up their hands and said, no, this doesn't look right to us. We have to look at this a little closer. They wind up in court. The court, and by the way, when the joint agreement was signed, what happens? That potential fraudster, if you will, the good guy who brought the old lady into the bank, signed the account agreement as well, which was great because now you have everybody's signature. The account agreement gave the authority to the bank to freeze all assets if there appeared to be some type of dispute or there seemed to be some type of fraud going on. Motion for summary judgment granted. Bank got right off the hook. The other two cases that we cited, Driver Doe and CGI Trading, interestingly enough, had nothing to do with elderly adults, nothing to do with consumer protection, but had everything to do with you have an agreement with your bank as part of your new account documents that allow the bank to hold and freeze accounts when they're doing an investigation. I think a lot of this harkens back when we were having AML conversations 10 years ago and 15 years ago when that was really ginning up. So like, we really don't think what you're doing is right. And this is far outside of, we're not talking about the Patriot Act here and things like that. But I think that's where this comes from. That if you want to protect assets, if you're the bank and you've got people's signatures on that, you're going to be okay. So where does this all end? So I go back to, I'm not comfortable telling a bank to put a hold harmless agreement in a customer agreement. I don't think it's against public policy. I don't think that it's unenforceable. I just don't know that it's necessary. And I just don't know that you want to put a court in that position to have to go that much further. It's definitely worth the conversation, but I think if your account agreement covers all of this in a real A, B, C, D, E, very clear lineup, I think that's preferable. So where does it end? Next slide, please. And then finally, so what do we take away from this? So we know that 2165 is designed to protect firms that act in good faith and provide the safe harbor from claims related to unauthorized use of client funds. And of course, as we say, there are limits, and that's the time limits that we talked about, that 55 days that's broken up a little bit. The safe harbor has to do with, you'll see civil cases will accuse banks of conversion, basically stealing the money. Obviously, FINRA rules apply to FINRA enforcement actions and things of that nature. The safe harbor is very important for banks, but it gives you those guide rails. How do you get around those guide rails? It appears, just from reading these cases, that as long as you address financial exploitation in your account agreement without specifying a hold period, and that's very intentional, because if you specify one that's way too long, let's say you say 100 days, right? Some courts may look at that and say, that seems like an awfully long period of time. Now, I know infinite, right, is a lot different than 100. But I think if you let your client know what you're doing, I think you're in a better position. These cases have shown us that. This gives you at least, by the way, if you don't specify a time, or you put in something like any amount of time which is reasonable under the circumstances. We talked about using that reasonability word. It comes up in the FINRA rule all the time. This will actually give you some cover should you exceed the time limits imposed by FINRA. But honestly, I think your bigger concern is outside litigation and finding courts that are going to be on your side. The FINRA lane goes one way, right? And the litigation lane goes another, and sometimes they don't always line up. So I would say make sure you're buttoned up with your account agreement, and in either directions you should be okay.
And to your point, Joe, the language in these JP Morgan agreements was really very broad. I mean,
Yeah.
setting aside the specific language for financial exploitation, the agreement literally said that they can close the account at any time for any reason or no reason without prior notice. And that language was upheld in the in the two matters that were cited that didn't involve a financial exploitation of a senior. But even with the financial exploitation, the language was just, we can put a hold or freeze your account if we suspect that you may be a victim of fraud, scam, or financial exploitation. Not even reasonably suspect, just suspect. It does follow up with language. We reasonably believe that doing so is necessary to avoid a loss or reduce risk to us. So there is that reasonable component, but generally speaking, it's very broad language that seemingly will be upheld if included in your contract. So there really is, I would say, no reason to not include it because it really will protect you in circumstances where, obviously you need to be somewhat reasonable. You can't just go around willy-nilly shutting down accounts. But if you're somewhat reasonable and you document, as you say, I think it will protect you in the long run for sure.
We can only help.
Yeah. Okay, and that brings us to our next section. And I believe one of the questions that we had pending did ask about trusted contact person. If you see some diminished capacity in a client, what are the next steps? You see someone being a little bit more forgetful. Is it just old age? When do you reach out to a trusted contact? I'm going to turn it over to Taylor to talk about a little bit more about the trusted contact person, how to best follow the statute, and what to do if there's potential that your trusted contact person is not the person you thought they were. Taylor?
All right, thanks, Angela. So FINRA Rule 4512 requires firms for customer accounts to make a reasonable effort to obtain the name and contact information for an individual that's 18 years or older that can serve as a trusted contact person. The purpose that FINRA had in mind in enacting this rule was to provide some safety from liability for the firm. So that way, if they suspected possible financial exploitation, something was going on with the account holder's health, they needed to figure out the legal guardian, the holder of a power of attorney, or anything else related to the customer, they could reach out to this previously designated individual and discuss that person's account. However, as we've seen, this can kind of serve as a catch-22. Firms are really encouraged to have their customers designate a trusted contact person, but we have not seen, or we've seen that come with some faults. On the next slide, let's see. 90% of the bad actors who end up committing financial exploitation are usually very close to the victims in their personal life, meaning that the primary risk is not financial advisors or someone at the firm. Next slide.
Sorry.
That's okay.
Which is we use this fact in other presentations. I find this quite amazing that 90% are close to their victims, but not seeing the litigation that we see. It's often the person closest to the victim that is the fraudster, but it's still 90% is a very large number. But sorry, go ahead, Taylor.
No, that's fine. So this right here is a chart that shows the breakdown of the most common perpetrators of financial exploitation of seniors. I'm not sure what happened with the chart, but you'll see the largest part of the graphic on the right, the dark blue, that is primarily the individual's children, particularly adult children. Behind that usually is friends and neighbors, about 17%. And then after friends and neighbors, it's usually caretakers, home health aides. So as you can see, it's usually someone who is very close to the individual. And oftentimes this would also, there's a high possibility that due to the close relationship that these perpetrators have with the account holder, oftentimes that's also the person who they would appoint as their trusted contact person. So firms should be aware that there is a possibility that this close friend or family member or caretaker that is designated as a trusted contact person could actually be a bad actor just because the individual at one time designated them to be able to communicate with the firm about their account. That doesn't mean, they're in the clear. So it's important that firms keep this in mind, that they are aware of any sudden drastic changes in the behavior of the account holder or, the trusted contact person, because that could be a red flag that exploitation is occurring. See, we have several new questions here. Let's see, this POA, trusted. How much information can an RIA supply to a trusted contact? Can you give account information?
Go ahead, Taylor.
Oh, okay. I believe that the firms are still supposed to refrain from giving out unfettered information to the trusted contact person. I think what is reasonably necessary would be good practice to confirm, if it's a suspicious transaction or if the individual starts making these large, unusual withdrawals, to reach out to that person and inquire. I wouldn't just start turning over all of the individual's account information or statements or things like that. I would just.
I do think that is another issue that can be addressed by language and agreements when you have the person give you a trusted contact. They're gonna sign on a piece of paper that says there's trusted contact, so you have an opportunity there to narrow or expand the information that you can provide to the trusted contact, and I suggest you expand it, not narrow it.
Yeah, I think that's a good point, Sarah, and I think everything has to be sort of on a case-by-case basis. I just know, just from anecdotally cases I've handled, oftentimes I have not seen a situation where the trusted contact person is a fraudster, but I have seen many situations where a POA is somehow got an elderly person to appoint them as POA and make them beneficiary. So I see the POA as more the problem than the TCP. I don't know if the other panelists have seen the TCP as the fraudster. And it's interesting because in this presentation, the 101 presentation, I feel like I always bring up that question. Well, what happens if the trusted contact person is in fact the fraudster? That would be an issue. I would think personally a way to resolve that problem is to perhaps make it so urge customers, or it shouldn't be mandatory, but urge customers to choose a trusted contact person separate from the POA. So while your POA may be a son or daughter, your TCP maybe should be, a longtime friend that maybe has no financial motive, is not a beneficiary of any sort, someone that's just a really good friend that's not going to have any motive to manipulate the individual. And this way you have an extra layer of protection. And right now, there's nothing saying that you can choose whoever you want to be your trusted contact person. I don't know what you guys have any thoughts on that. I feel like that would be a good idea as an extra layer of protection for the individual to have a different TCP and then as your POA.
Assuming that they have sufficient family or friends with that type of a relationship where they can have a choice. I mean, the problem is that, a lot of people in our modern world do not have as many close relationships as would protect them from this sort of situation.
I think part of the problem you have with making those choices is number one, and we talk about this in the 101, is isolation, right? Folks who are older don't have the kind of people that they can rely on to doing this. And number two, quite honestly, and I've run into this in cases, either POAs, well, I think sometimes don't really recognize the amount of power they're actually being given and the amount of responsibility necessary to do that. Outside of my work at Bressler, I was asked to be someone's POA as a referral from another lawyer who happens to know this person. And I turned it down because I have no idea who these people are. I have no idea what their lifestyle is about. And I think I was supposed to be second in line. Can't do that. The problem we run into, though, is there are plenty of people who are appointed as POAs and TCPs who are absolutely positively not qualified to do that job, whether just because of general sophistication, or they're making just because I'm your friend doesn't mean there's somebody I can help with your affairs. So everybody talks about POAs as having this really sacrosanct existence, and TCPs as well. But I think as the bank has to be aware of who these people are. And you really can't interview a POA and ask them whether or not they're qualified because they've signed a legal document and you're kind of stuck with that. But if you've got a TCP, I don't think it's a bad idea to have a sit down with everybody every once in a while, just to make sure the TCP is as up to date and understanding as the person who your client is. And maybe, and I know most brokers won't want to do this because it does fall on the line of respecting people's privacy, is have a conversation about whether or not TCP is the right person to do it. Hard conversations all around. But just because you're assigned to do something doesn't mean you're qualified.
And that's a great point, Joe. And again, it falls down to the whole privacy versus investor protection. And that's a balancing act that constantly has to be made. And to more specifically respond to the question that was posed, and for some reason, I can't see all the questions on my screen. I'm not sure why, so I
You
apologize.
scroll down, sometimes you have to do that. The Mac might not let you do it though.
Yeah, you have to scroll.
And my Mac is not letting me. I apologize. It's not letting me scroll down. So I think it is I think if you see a client that has a diminished capacity, have the financial advisor speak to them, document it. And if you do need to speak to the trusted contact person, maybe it comes to a point where you're going to bring them into the loop. It just has to be a brief conversation. Like I've been speaking to John. He seems like he's this, and this. What have you noticed? And it doesn't have to be a deep conversation where you're revealing all this information, just more of a check-in. And again, it has to be on a case-by-case basis to see when it's appropriate, but always important to document and to make sure that there is a record of what you've been doing to make sure that your covenant as a client is protected.
So
and
some of the stuff
also-
that's, I'm
ahead.
sorry, Angela, some of the stuff that's coming up in the chat, which I think we're going to have to answer individually because we're not going to have time to finish it. First one is it being recorded and there's going to be a replay? Yes, it's being recorded. And I would imagine that there's some way for folks to replay this.
Yes, there is.
Okay.
Yes, there is. You
excellent.
look up, so you'll know. It won't happen like, in the next 5 seconds, but if you go to the Bressler website and you look up one of the speakers here, under their activities, you will find a link to the webinars that they have appeared in. So yes, it will be recorded and it will be replayed.
Excellent. Thank you, Sarah.
Thank
I think we've got a couple of multi-level questions here that we're going to have to discuss answering offline. They're really good ones, but I don't know that we can get to everything.
Yes.
Okay, but there is one that somebody asked regarding POAs that I think is fairly straightforward. Can you discuss what steps you take when you've accepted a POA, but you're refusing to follow specific instruction because you suspect exploitation, etc.? If you find yourself in that situation, you're going back to square one. Okay, you're going back to contacting the trusted contact. You're going back to imposing a hold that applies under FINRA rules or under state statutes. And you're going back through that entire procedure again, because now you are correct. You are no longer in the position of that you accept the POA, that you not accept the POA. You are basically in the position in which a transaction or transactions under the POA have led you to suspect exploitation.
Okay. Thank you, Sarah. So finally, with the last couple minutes, we're going to just briefly talk about, but I reported it. You did what you were supposed to do. You involved law enforcement and or APS, but no action was taken. And just really quick, Alex has some thoughts on this, but I just will give you a little scenario. I had a matter which a client reached out about where they had a 75-year-old woman that had appointed her neighbor as a POA, and there was a lot of suspicion about this neighbor who apparently told her to got her to transfer her account to this broker dealer, as well as make him the beneficiary. And there was all this suspicion around him, and it was in Florida. They reported it to APS. They reported to local law enforcement. Law enforcement did a check-in. APS got the report. When the broker dealer checked in, they weren't able to share any of the information with them. And I'm truncating the story, but next thing you know, the POA fraudster neighbor was reaching out to the firm with a sort of pseudo POA in his hand saying, I want access to the account. And they had done what they were supposed to do. And suddenly there they were. It was like a holiday weekend. And probably that was strategic on the fraudster's part. And they reached out to outside counsel. They reached out to us to try to help them figure out what was going on. So they did everything they were supposed to do. And there was the fraudster saying, I have this POA and I want access to the account, or there's going to be legal action taken. So that's a quick summary of the story. The point is that this stuff comes up when you've done everything you're supposed to do. It doesn't mean the problem is going to go away. So what are some suggestions of how to deal with such a situation? And I know, like I said, Alex had some thoughts on it. Alex?
Thank you again, Angela. Basically, it's all summed up in the title. You got to know the law's applicable time periods, and you got to know what your account agreement provides in terms of placing a hold. Because, for example, as I pointed out here, and I'm talking Florida because I'm a Florida lawyer, the Office of Financial Regulation doesn't have a time period during which they have to complete their investigation. Adult Protective Services is supposed to start within 24 hours of getting a hotline report, but they have 60 days to complete it. The only requirement for law enforcement, if there's a separate law enforcement investigation, is you have to tell people they have to tell the state agency and the state attorney and the Department of Children and Families, which is APS is part of that in Florida, within 5 days of completing the investigation. They don't have to complete it in any period of time. So you can see that you're getting to that point where in the back of your mind, you're hearing the Double Jeopardy theme song play and you're thinking, oh my gosh, what's going to happen next? But we do have some suggestions. So let's go to the suggestions. Okay. In Florida, like I said, the Office of Financial Regulation can conduct investigations, which are confidential, and they can get injunctive relief. So you provide the information you're supposed to provide to the Office of Financial Regulation, but if you're concerned and it's serious, make a separate report and ask for an investigation. Emphasize what's going on and very, very specifically say, and I think you need to move quickly because we can only place our hold for 25 business days or maybe longer if your contract provides. The same thing with Adult Protective Services. If you make the report and you think they need to move quickly, tell them. I mean, I've done that in cases on behalf of clients, and I've had the experience of getting the OFR investigator call, or the APS investigator call back and say, yeah, we were just out there, and they report what they found. They went out there within 24 hours. And like we've talked throughout this, the language of the account agreement can provide a basis to impose a longer hold. But remember, if you're going to report it to a state agency and you think they need to move very quickly, tell them and tell them why. And you can do that if you conduct your investigation and you keep the facts and you write them all down. Just let them know what your concerns are. Again, you're creating evidence that will stand you in good stead if you're ever sued.
Thank you, Alex. And I see we have run out of time. I will just say that in the case I just referenced, what ended up happening is the POA was litigated and the judge upheld the POA reluctantly, but also appointed a trustee to assist the elderly victim, who we found out had taken things into control and was handling the situation. But we didn't realize that. It took some investigation. So with that, I see that we are a little bit over time. I will give everybody the final code, which is Thanksgiving. So a happy Thanksgiving to everyone. And we apologize that we were not able to get to everybody's questions. We will do our best to answer them. Please feel free to reach out to any one of us or the group of us to ask any additional questions you may have. We are more than happy to answer them. And thank you very much for joining us today. We hope you enjoyed it and found it educational. And Alex?
If you want to send us an email and ask for the recipe, I was going to talk about a recipe on how to make your Thanksgiving turkey.
I would suggest reaching out. Alex always has a good recipe. So thanks, everybody. Have a great day.
Thank you.